Good evening, everyone. Thank you so much for joining us for the third session of the Federalist Society Student Division's Challenge to Originalism series. My name is Sarah Williams, and I am the president of the Texas A&M University School of Law student chapter of the Federalist Society. For 10 consecutive Tuesday nights at 8 p.m., the Student Division will host a Zoom series called Challenges to Originalism, which will feature a rotating student chapter president interviewing originalism expert, Professor Lee Strang. Professor Strang will lay out 10 of the most common criticisms of originalism from both the left and the right, and respond to some of the legal theory's most formidable foes. Please feel free to submit your questions tonight at any time via the Q&A feature on Zoom. The Texas A&M student chapter of the Federalist Society is honored to host tonight's session of this series, where Professor Strang will respond to the challenge that originalism is inconsistent with stare decisis. It's now my privilege to introduce Professor Lee Strang. Professor Strang is a graduate of the University of Iowa College of Law and Harvard Law School. He is currently the John W. Stepler Professor of Law and Values at the University of Toledo and is the founding director of the Institute of American Constitutional Thought and Leadership. Before joining the University of Toledo, Professor Strang was a visiting professor at Michigan State University College of Law, a visiting scholar at the Georgetown Center for the Constitution, and a visiting fellow at the James Madison Program at Princeton University. Prior to pursuing academia, Professor Strang clerked for Judge Alice M. Batchelder on the Sixth Circuit Court of Appeals and practiced law at Jenner & Block. Professor Strang is also a prolific scholar and has published dozens of articles on constitutional law and interpretation and religion in the First Amendment. His most recent book, Originalism's Promise, is the first book-length natural law justification for originalism. Professor Strang is currently editing the third edition of his casebook, Federal Constitutional Law, and finishing a book on the history of Catholic legal education in the United States. Professor Strang, it's wonderful to be here with you tonight. Before we kick off tonight's session, is there anything you'd like to say first?
Yeah, well, thank you for the warm introduction, Sarah. This has been a wonderful series where each week we tried to identify one of the common and powerful challenges to originalism. Our audience is law students like yourself, it's lawyers, and it's also average Americans. And so what we're trying to do is highlight some of the best criticisms that are out there and then some of the best originalist responses to those. And this is one of my favorites. Stare decisis was a really hot area about 20 years ago, and it's become a really hot area again for some of the cases I'm sure that we'll end up getting questions about.
Absolutely. Well, last week, for those of you who are able to join, Professor Strang addressed the threshold challenge that originalism is impracticable. But tonight, we're going to do a deep dive into originalism and explore the challenge that Professor Strang mentioned, that originalism is inconsistent with stare decisis. So my first question for you tonight, Professor Strang, is what were originalists' initial views on originalism's relationship with stare decisis?
Yeah, thanks for the question, Sarah. It gives me a chance to just step back for a moment. So originalism in its modern form came on board in the early 1970s. And at that point, the main perspective and the main goal of originalist scholars like Judge Bork and then Raoul Berger was to criticize what they viewed as the misinterpretations of the U.S. Supreme Court during the Warren and Berger court eras. And so they really didn't spend much time thinking through stare decisis. And if anything, it seems like their kind of default perspective was that stare decisis was maybe valuable, but it was actually a tool being used by the Supreme Court to misinterpret and then kind of entrench those misinterpretations in the practice of stare decisis. And when originalists first started thinking about stare decisis, I think it's fair to say that the originalist perspective was that stare decisis maybe has some role in some areas, but when it came to non-originalist precedents, which are precedents that incorrectly interpret the Constitution, The Originalist rule appeared to be, the Originalist convention appeared to be that those precedents need to be overruled. And if you think about it, there's a really strong reason for having that perspective. And it's the kind of three main commitments of originalism. So the first originalist commitment is what's called the fixation thesis, which is that the Constitution's meaning is fixed when it was adopted. Second is the public meaning thesis. That fixed meaning is the Constitution's public meaning at the time. And then third, the constraint principle, which says that officials should follow that fixed original meaning. And if you look at those three propositions, none of them involve stare decisis. And if you think that there can be incorrect precedents not following the original meaning, which I think everybody agrees exists, then the corollary would be that originalism would reject non-originalist precedent. And since there's a lot of non-originalist precedent out there, there's a basis for criticism of originalism destabilizing the original meaning. And I think the best article for those who are interested in reading is the 1990, I think, 4 article by Gary Lawson, which is The Constitutional Case Against Precedent. And Professor Lawson, very elegant, very, very, very simple argument, which is the way that he writes. He had 3 propositions. Proposition number 1, the Constitution is the supreme law of the land. Proposition number 2, Supreme Court precedents are not the Constitution. Conclusion, Supreme Court precedents that are inconsistent with the Constitution need to be overruled. And I think that was the originalist position, I want to say, up until the early 2000s.
Well, wonderful. Along those lines, can you talk to us a little bit about who are the key critics and what are these critics' main arguments that originalism is inconsistent with stare decisis?
Yeah. So the critics started really off the bat. So one of the kind of seminal pieces of criticism that I've referenced now in each of these episodes, and we'll come back again in future episodes, is a 19 article by Paul Brest, which is about the original understanding of original intent, and it's from 1980 Boston University Law Review. And what Brest articulated what I think are 4 of the main criticisms of originalism. So the first one that he articulated, which I think is pretty common, anybody who's had constitutional law like yourself, you know, there are a lot of precedents that are inconsistent with the Constitution's original meaning. And so if you agree with that proposition, and if you agree with the Lawson view about how originalism should deal with non-originalist precedent, the conclusion is there's a lot of non-originalist precedent, including some that's been around for a really long time, some that's really important to our legal system, that's going to be overruled. And Brent's perspective, which is a very reasonable one, is that dramatic destabilization of American law on balance is bad. And so the extent that originalism does that, that makes originalism bad as well. The second criticism is kind of a related version of that first criticism. It says it agrees with both points. Originalism is inconsistent with non-originalist precedent. And second, that there's a lot of non-originalist precedent, but it focuses on a subset of that non-originalist precedent. So I don't know if you bumped into the idea of canonical cases, that there are some cases in the U.S. Supreme Court canon, in the U.S. reports, that are the most important cases. So Marbury versus Madison would be an example. Brown versus Board would be an example. And so what these critics argue is they say a large number of those canonical cases, which are the most fundamental Supreme Court cases in American history, are non-originalist precedents, and originalism would require overruling these really important canonical precedents. And a lot of these precedents people today think are sound precedents. So like Brown versus Board of Education, or one I just taught today was West Virginia Board of Education versus Barnett. And that was the flag salute case where West Virginia was making students, including Jehovah's Witnesses, do the Pledge of Allegiance. So the second criticism is that originalism would require overruling these really important canonical precedents. And then the third criticism is looking at, so what if, let's say that, so there are, I think, 3 basic positions that originalists can take regarding precedent. One I call get rid of it all, which is really the Lawson position. The second would be get rid of some but not all non-originalist precedents, so kind of a middle of the road position. And the third position might be follow all precedents. Now that last one, I don't think is actually an originalist position, because if you're just following all the precedent, what you're doing is living constitutionalism, and originalism isn't playing any role. So let's say that you were an originalist who was sympathetic to those first 2 criticisms. Wow, we have to overrule all those precedents, including Brown versus Board of Education. That seems like a terrible idea. And so you might be inclined to say, okay, let's take a middle of the road position and authorize or require judges to overrule, to follow some, to limit some, and to overrule some non-originalist precedent. But once you're doing that, what you're doing is you're opening up, according to the critics, a kind of Pandora's box of discretion. So in some ways, this position from the critic's perspective is actually worse than anything. So you don't have the constraint of the original meaning, and you don't have the constraint of living constitutionalism. So what you have is a judge who, according to the critic's perspective, is going to use his or her own policy views, political views, to decide whether to follow, to limit, or to overrule a precedent. And the fourth criticism, Sarah, I think is actually the most fundamental. It's the argument that our Constitution isn't just the document in the National Archives, like originalists argue. Our Constitution is actually that plus at least some Supreme Court precedent. So if it's the case that our Constitution actually is or includes Supreme Court precedent, and if it's the case that originalism would require overruling some of that Supreme Court precedent, what that means is that originalism's overruling the Constitution, which is an oxymoron. That can't happen. And so this really foundational criticism relies on what we would call a Hardian perspective after HLA Hart to describe what is the law. You look at what current legal officials say or act as the law is, and what these critics say is that the current law in the United States is the Constitution in the National Archives, but it also includes a lot of Supreme Court precedent, including non-originalist precedent. And I think David Strauss's Living Constitutionalism book is an example of that. And then Richard Fallon's book, Legitimacy and the Supreme Court, is an example of that view. And so if one holds that view that the Constitution is what legal officials say it is, and if that includes non-originalist precedent, then originalism actually isn't doing constitutional interpretation at all. It's like missing the boat. So I think those are the four big criticisms that are out there.
Well, with those being laid out, I'm going to ask you a broad question. How do originalists respond to these four major critiques of originalism?
Yeah. So I'm not going to answer them kind of one at a time. What I'd like to do is I'd like to step back and kind of narrow the focus here. So when you think about what does stare decisis do, stare decisis operates in lots of areas of American law. It operates in the common law system. It operates regarding statutory interpretation, and originalism has nothing to do with that. It also operates in the context of originalist precedents. So something we haven't talked about because critics don't talk about is that there's actually a lot of originalist precedent out there as well. That's precedent that correctly interprets and applies the original meaning. And so originalism is happy with that, is fine with that. And so what we're really talking about is a small sliver, an important sliver, but still a sliver of all the universe of the practices of stare decisis. And so it's a way to kind of narrow the criticism that all we're talking about here is just one slice of stare decisis. The second kind of stepping back I want to do is to I guess reject the premise, at least in some situations. So the premise of all the criticisms, except for the foundational one, the premise of all the criticisms is that at least some and perhaps many Supreme Court precedents are non-originalist precedents, but that's actually a point in contention. So for example, regarding Brown versus Board of Education, there's a famous 1995 article by Michael McConnell saying that Brown is an originalist decision. There's been lots of other arguments as well that are out there. And I'm not vouching for one side or another regarding any particular precedent. What I'm saying is that the second step we'd have to confirm for the critics to be right is that in fact these precedents are non-originalist. And I think for many of the precedents that are criticized, I think that originalists have sound, in some instances, very powerful arguments that the purportedly non-originalist precedent is in fact an originalist precedent. So just thinking of Brown in particular, one of the things that I think has been wonderful over the last, I want to say 15 to 20 years, has been the revival of scholarship on the privileges or immunities clause in the 14th Amendment. And I think the scholarly consensus among originalists is that clause requires, and it wouldn't just require for the states, but would require for the federal government as well, treating all citizens equally, which would include treating all citizens equally regarding the good of education. Okay, so where's that get us to, Sarah? That gets us to, we are at a point where we've narrowed it down to precedents that in fact are non-originalist. And this is really where the rubber meets the road. And I think there are three camps of originalists at this point. So one is the Lawson camp, the one that I mentioned earlier, where the view among the original scholars, among a large set of original scholars, is that the original meaning, if the original meaning is inconsistent with the precedent, then the Supreme Court or whatever the relevant court is should overrule that precedent. And it's kind of get rid of it all, not quite. There's some kind of mechanisms to try and make it less traumatic than it might sound. This is actually something like Justice Thomas's view. So in the Gamble case, 2018 case, Justice Thomas articulated his view of stare decisis, and his view basically is that if there's a precedent that's clearly incorrect, or I think his phrase is demonstrably incorrect, then there's no other analysis. You overrule it. And so that's almost, but not quite, get rid of it all. So that's one camp. And so if you're in that camp, which many scholars are, then what that means is, yeah, you overrule these incorrect non-originalist precedents. And it's actually, there may be some negatives with it, right? With destabilization and loss of reliance interest and things like that. But from these scholars' perspectives, originalism is itself really valuable. And so whatever the harm is more than compensated by the value that originalism brings to our entire legal system. The other camp, which is kind of the middle of the road camp, is actually where I fall. And in my view, I would say this is, it might be the majority view right now, something like this view, is that, and different scholars have different analyses, but my view is that when it comes to any particular precedent, what the judge should do is they should decide whether the precedent is a deviation from the original meaning and how much it's a deviation. Second factor, would overruling, or to what extent would overruling the precedent harm rule of law values? Third, would overruling the precedent create unjust or eliminate just social relationships among Americans? And so those are three different factors. This is, I think, just a fair criticism. It does provide a lot of discretion in judges when applying those three different factors. And so you might say, well, then why do that system? And the answer that I give and other scholars give for this kind of middle of the roadway is that it's actually what the Constitution requires. So in my scholarship, what I've argued, and other scholars have followed this argument, is that the original meaning of judicial power in Article 3 requires federal judges to give significant respect to precedent. And what that means is, in some instances, they'll follow it, in some instances, they'll limit it, and in some instances, they'll overrule that precedent. And so why should judges have that discretion? My answer is because it's what the Constitution commands. It's really kind of a second best world, because we're not in a world where we're following the original meaning. And so by definition, we're kind of doing something different. And the question is, what's the best way to get us back to the first best world? And stare decisis using this analysis is the right way to do that. I guess the one last thing I would say, Sarah, on this point is, you might say, well, why do the different originalists have different views about stare decisis? And I think this is actually an issue that originalists are working through right now. I think for those students who are out there, I think it could be a great opportunity for students to write a law review note and make a real contribution, because with a working majority of justices in the Supreme Court who are, at least in many instances, inclined towards originalism, this question of overruling or limiting or following is going to keep coming up over and over. So the last criticism, Sarah, the one about foundational, that the Constitution includes Supreme Court precedent, I said that that's actually, I think, a very powerful criticism. And I think really the only way to meet it is to push back and argue that, in fact, our legal system is committed to the proposition that the Big C Constitution is just the document in the National Archives. And there's lots of reasons to think that, but I'll just give you kind of one anecdote that you as a law student might be familiar with. I don't know if you've taken criminal procedure and done Miranda and Dickerson. So the Dickerson versus US case was after 30 years of precedents narrowing Miranda, written by Justice and then later Chief Justice Rehnquist. And at each step along the way of the narrowing, Justice Rehnquist would say something like, Miranda is not constitutionally required. And then he gets to the Dickerson case, and there's a whole bunch of stories about why he might have written the majority opinion. But in an opinion with a conclusion that nobody, I think, defends as an originalist decision, Justice Rehnquist feels compelled to say, even if it doesn't seem true, feels compelled to say that the Constitution made me do it. Now, and so what's the insight of that? What it's suggesting is that the Supreme Court's practice is not to treat its precedent as the Constitution. The Supreme Court's practice is to only treat the Big C Constitution as the Constitution. And so originalists have made arguments like that. I think two scholars, Will Baud and Steve Sachs, have made arguments like that. I've made arguments like that as well, to say that our Constitution, in fact, is and is only the Big C Constitution. So that's the response to the criticisms, Sarah.
Well, very powerful responses. So I'm going to pivot a little to a question that I think is probably on many of our minds right now. Do you think that the recent overruling of Roe and Casey by Dobbs is in line with originalist thinking?
Yeah, that's a tough one, actually. Originalists have been debating that. I think one of the best pieces that's out there is by two scholars, Randy Barnett and Larry Solom, talking about Dobbs, Bruin, and then another case called Kennedy versus Bremerton. And in this context, here's what I think is going on. So the Dobbs case overruled Roe and Casey. So basically 50 years of precedent And what makes the Dobbs opinion written by Justice Alito kind of challenging from an originalist perspective is that it doesn't sound like an originalist opinion. It doesn't talk about text and history and structure and tradition. What he talks about is really substantive due process type of analysis. He uses the Washington versus Glucksberg analysis of history and tradition, goes back to 1868, looks for histories and traditions at that time, but not necessarily pointed to the original meaning of the 14th Amendment. So how can you count an opinion that doesn't use originalism as an originalist opinion? And if it's not an originalist opinion, then what work does originalism do on the Supreme Court that purportedly is made up of originalist justices? And so I've been thinking about that. Other scholars have been thinking about that as well. And it's super important, Sarah, because the answer to this question will also likely inform answers to other future questions where questions about overruling cases come up. And I think the answer is actually kind of has three steps to it. So the first is to think, what kind of area of law was Dobbs, Casey, and Roe in? It was an area of law that I call eclectic, which means it had some original stuff and it had some non-original stuff. And it was kind of mixed up and mumbled up together and really didn't have any particular center of gravity. It was kind of, it was in tension, internal tension between originalism and non-originalism. And so what should a justice do in that situation? Here's step two. I think that an originalist justice has in his or her heart, and it's actually, I think, a judicial virtue, the virtue of justice's lawfulness, where they're inclined to follow the original meaning if they can. And another way to think about that is that the original meaning has a gravitational effect on the law, and it's kind of pulling judges to move the doctrine towards the original meaning. And this idea of gravitational effect, it may sound mysterious, I'm not sure, but it's actually a widespread view among scholars, and it actually explains a lot of what the Supreme Court does, that you look for what is the center of gravity in an area of law, and then you see the surrounding doctrines get pulled into it. And actually, the person who articulated this is the leading liberal scholar, Ronald Dworkin, back in the 1970s. So it's definitely not an originalist idea. I think it's just a phenomenon of at least Anglo-American law. And so you've got an eclectic body of law that the justices in the court are trying to pull the doctrine back towards originalism. So in other words, to move it away from non-originalism to originalism. And then third, stare decisis is the tool by which the justices use to navigate the doctrine back towards the original meaning. And so I think when you have it in that light, what you see is that Dobbs is an opinion by a justice who's inclined to move the doctrine towards the original meaning, and using the standard tools of stare decisis, which the opinion deals with, right? The opinion has all these different factors of stare decisis to move the doctrine back towards the original meaning. So when you put all those things together, I think you end up seeing that that Dobbs actually is an originalist precedent. And actually, I think it's a model for how the Supreme Court should operate in other areas of eclectic bodies of law. There's a question from a student. Should we take that question, Sarah?
Yes, absolutely. Question says, Professor McGinnis and Rappaport released an originalist approach to prospective overruling in the Notre Dame Law Review. The two criticized Justice Thomas's, quote, demonstrably erroneous standard. The professors claim that the Constitution treats precedent as federal common law, revisable by Congress. They also claim that the practice of applying stare decisis to decisions interpreting statutes occurred pre and post ratification, weakening Justice Thomas's thesis. The professors also say that this practice stretched back to England as well, prohibiting judges from overriding or rewriting statutes because precedent rules were tied to parliamentary supremacy, not common law. So the question is, would parliamentary supremacy not being formally recognized in the United States weaken these professors' positions? Should Congress not play a greater role in rectifying the reliance interests that could be upset by more aggressive precedent cutting? And would inertia in Congress indicate perhaps the non-originalist opinion isn't as powerful as we thought?
Yeah, that's a great question, very sophisticated question, and it relies on two extraordinary scholars, John McGinnis and Mike Rappaport, who have an extraordinary book, right? The Good Constitution, which is their theory about the Constitution, which includes a large section regarding stare decisis. So they've grappled with this issue, and whatever they say is something really thoughtful. So a couple of interesting points I think stick out from both McGinnis and Rappaport's and then Michael Potter's question. So what I see McGinnis and Rappaport is doing is laying out a position slightly different than what I articulated, but kind of a cousin. And so I think their position is that Article 3 doesn't, through its original meaning, require judges to respect precedent, but that Article 3 is what originalists might call, this is not their description, this is my description of their work, just to be clear, might call in the construction zone. So the construction zone is an area where the law is underdetermined and that different officers can construct constitutional meaning. And so that would be one reason why Congress could revise the federal court's approach to stare decisis. They also may be saying something slightly different, which is that the original meaning is just the common law meaning of precedent, and that as well is also subject to congressional revision. And so one of the things that's attractive about that approach is that about the approach of letting Congress have a role, and presumably the role will be under the necessary and proper clause, which allows Congress to pass laws that are necessary to the foregoing Article 1 and other powers granted by the Constitution, is that it would allow Congress to give input, as Michael Potter is suggesting, about whether Congress thinks that there's a lot of reliance interest at stake here, whether Congress thinks that a precedent is an incorrect interpretation of the Constitution. So it would give that feedback as well. I think there is, so one of the last question, part of the question that I'll respond to is that the move from parliamentary supremacy to the United States system, which has some version of popular sovereignty. There's debates about what kind it is. And my own perspective, for what it's worth, is that I don't know if there is much impact in the doctrine of stare decisis, or at least when I read the historical record, I don't see much impact in the conception of the doctrine of stare decisis being impacted by the change in conceptions of popular sovereignty. And just one example that Michael can read is when you read Federalist 78 and Alexander Hamilton's debates with Brutus, you see both of them assuming and relying on a conception of stare decisis, and neither of them is relying on a conception that seems to be different than what they inherited from England, despite the difference in popular sovereignty. So great question.
Well, going to take another question from the chat here from
Sure.
Gregory Fasliotis. He asks, what role would stare decisis play in maintaining due process incorporation instead of reviving privileges and immunities for an originalist?
Yeah, so wonderful question. And let me just describe each of the premises. So the doctrine of incorporation is the idea that the due process clause of the 14th Amendment applies the Bill of Rights and maybe some other stuff to the states. That was a very controversial process. I think most scholars today say that the due process clause was not originally meant to do that. But I think there is a deep scholarly consensus today that the privileges or immunities clause of the 14th Amendment would have been the vehicle to appropriately do that. And so the question's asking, what role should stare decisis play in maintaining the current doctrine as opposed to switching it over to privileges or immunities? Now, my answer would be, it depends on which version of originalism one follows. So if you follow the get rid of it all position, I think what you would say would be that, this is actually the Thomas position in McDonald versus Chicago, which is, okay, we made this mistake, due process clause, let's get rid of that precedent, and let's do the right thing, which is to incorporate the Bill of Rights under the privileges or immunities clause. The alternative approach, the kind of middle of the road approach that other groups of scholars follow, would say that it depends. So is incorporation under the due process clause a deviation from the original meaning? The answer is clearly yes, but in one sense, it's actually not much of a deviation at all because incorporation was meant to be the case anyway. Second, would incorporation, would overruling and then reincorporating harm rule of law values? And that's honestly kind of mixed because it would depend on when it happened and how it happened. So if you had overruling and then you had a period of time before you had reincorporation, that would cause dramatic instability. And that's just a very off-the-cuff judgment. Third, would overruling harm rule, would it create unjust relationships? Well, to the extent that one thinks that the Incorporated Bill of Rights creates juster relationships between states and their citizens, then the answer is yes. Although, again, it depends on how long it would take before the reincorporation occurred to recreate those just relationships that we had previously. So the answer, I think, depends on what your version of originalism is. And I think Justice Thomas is one example, and I think Justice Scalia in McDonald versus Chicago in his concurrence is the kind of middle of the road position that I've been articulating.
Well, speaking of Justice Scalia said that stare decisis is not part of my originalist philosophy. It's a pragmatic exception to it. And Professor Jamal Green has written that a consistent originalist could easily conclude that the court's jurisprudence on women's rights and the use of paper money as legal tender, the use of federal commerce power to establish the welfare state, and federal civil rights laws and the federal administrative itself are are all unconstitutional. So why shouldn't the consistent originalists reject whole bodies of law? And do originalists accept stare decisis only for pragmatic reasons?
Yeah, I think so. The first question, why should originalists not reject whole bodies of law? I think it depends on what your view, your originalist view of stare decisis is. And that is there's the get rid of it all position, and then there's the kind of middle of the road position. And I think if you're rid of it all, your position is so long as you think this is Thomas's position, it's demonstrably erroneous, which many of those precedents are, in my view. So Wickard versus Filburn, I think, is demonstrably erroneous. And then you would overrule Wickard, and then the whole substantial effects test comes crashing down. The middle of the road position would be, for what it's worth, harder to predict because you would have to, in a case by case and doctrine by doctrine basis, decide those three different factors that I had identified. And just as kind of one point that people might have in their minds, wow, that's a lot of work for judges that on a case by case and doctrine by doctrine basis, you have to decide, do we limit, do we follow, do we overrule? And I think that's what the Constitution requires. And so therefore, we kind of have to suck it up and do it. But I think there's actually a way in which originalism can utilize that to its value. And it's especially the case when you can incorporate an idea of judicial virtues. So the idea is that judging is hard, and you need men and women who have certain characteristics, certain virtues, we call them the judicial virtues, to be able to do it well. And I think the decisions about whether to follow or overrule non-originalist precedent are some of the most challenging that judges have. And so we need judges with the virtue of justice's lawfulness, which is they're inclined to follow the original meaning. The virtue of theoretical wisdom, which is they've mastered the original meaning. I love Justice Thomas's opinions because of that. He just does such a great job laying out the original meaning. And number three, practical wisdom. If we overrule this decision, what are the practical implications to rule of law that would follow from that? Okay, so the second part of the question was, do originalists accept stare decisis only for pragmatic reasons? And I think the answer is no, that what I've described is that originalists across the board are trying to say, what does the Constitution require us to do? What does the law require us to do when it comes to incorrect precedent? Do we follow it? Do we overrule it? Do we follow some and not others? And so all the originalists I'm familiar with are trying to work within that vein, trying to find out what the Constitution actually requires. I would say there's one maybe caveat to that. I think there are some originalists who think that the Constitution's original meaning neither requires nor prohibits judges from following precedent. And if that's the situation, we would call that an area of underdeterminacy, an area of constitutional construction. And in that area, different scholars, different judges, different Congresses could construct how the courts approach stare decisis. And if that's the case, in other words, if the law leaves it up to the officials, which is what I'm hypothesizing, then pragmatic reasons would play a role because you'd want to do what's pragmatically best. So it's a long way of saying that pragmatic considerations are either don't exist or are very low in the totem pole.
Excellent. Well, question from Stephen Englander. He asks, how do originalists handle conscious decisions of the founders to future-proof in the choice of words or text used in the U.S. Constitution? Is anyone looking into this?
So what I understand the question to be is, so the founders tried to craft a text that would bind future interpreters to follow that meaning of the text is how I'm understanding that question. And I think there's a way in which I don't know if stare decisis plays a significant role in that. And so I'll just answer the question directly, not putting the stare decisis cap on. I'm not aware of anybody. So there's certainly the case that there's a lot of literature about the framers and ratifiers having different motivations, different goals, different tools, different techniques to try to implement the decisions that they made in Philadelphia, the ratification conventions, and then later amendments through Congress. But I'm not aware of anybody specifically considering a proposition of the framers trying to future-proof a decision. Maybe one kind of mini caveat to that would be there is a prohibition on states having other states carved out of them. So that might be an example without that state's consent. So that might be an example where if I was looking into this phenomenon of future proofing, I might look into that. And the reason behind that particular provision was many states were worried about getting absorbed into this amalgamation of this new national government. And one way to protect it was to make sure that the states had the final veto over whether they were carved up into two or more states. And so I might look for instances where the people who are participating in the framing ratification were really worried about something and worked hard to prevent that bad thing from happening.
Excellent. Well, another question for you. Do judges have to choose between pragmatically keeping law settled versus correcting erroneous precedent? At what point in the analysis does overturning a long traditional understanding outweigh the costs in doing so? And does there have to be a particularly important constitutional right at stake, no matter how small the error? Or does the subject matter not matter as much as the magnitude of the error?
Yeah, so there are a lot of different factors going on in that question. And the way that I would answer it would be to say, all the originalists I'm aware of are looking for what does the law tell judges and others to do in situations of mistaken interpretations. And so, as I was saying earlier, the answer might be the law says reject them all. The answer probably isn't follow them all. I've not seen that argument out there. And so, only other alternative is follow some, but not follow others. And so, do judges have to pragmatically choose? I think the originalist perspective is it's not about pragmatism, it's about what the Constitution requires. And only if the Constitution requires the relevant interpreter to take into account pragmatic considerations should the interpreter take into account pragmatic considerations. That's actually my view, the one I articulated, which is one of the pragmatic considerations is if we overrule this precedent, how much will it harm rule of law values? That's in some ways, one way to think about it is a pragmatic consideration. I actually call it a prudential consideration because I'm trying to harken back to the idea of the judicial virtues. And actually, this would be another place to spend just a moment on that idea. So let's say that the Constitution tells judges, this is my view, that they need to take into account those three factors, and that each of those three factors is itself kind of a challenging analysis. What you need is judges who have the virtues to be able to do those challenging analyses, not perfectly, right? Because we humans don't do things perfectly, but as good as humanly possible. And so, for example, in the question of how much of a deviation is the precedent from the original meaning, what we need is a judge who has the intellectual firepower to both identify the original meaning and number two, compare it to the actual precedent. So we need judges to master two bodies of law and kind of put the two together. And the same would occur for the other two factors as well. Sarah, do you want to take one of the questions from the chat or from the Q&A?
Absolutely. This question comes from Jonathan Voos. He asks, an increasing number of originalist scholars like Ilan Warman in his forthcoming book have found that 14th Amendment incorporation was improper in the first place, even under the Privileges or Immunities Clause. He says, assuming for the sake of argument that Warman is correct, how would an originalist approach potentially unwinding 100 years of precedent as opposed to merely shifting incorporation from substantive due process to privileges and immunities?
Yeah, so it's a really wonderful question. And I want to generalize just a little bit and then come back to the question. So the generalization is that there's a lot of ways in which if you're an originalist justice in the Supreme Court right now, you face a question like this all the time, right? So Dobbs was a question where you had a 50-year-old precedent. But imagine you have imagine you're in Lopez versus US 1995, NFIB versus Sebelius 2010, 2012. And so you're 70 years away from the Wickard versus Filburn case. And so this question is coming up a lot. And I think what the correct originalist approach. So again, I'm not the get rid of it all person. So Justice Thomas is that person, and that answer is it's elegant, it's simple, right? Which is you overrule that bad precedent, and there's going to be some rocking in the seas for a while, but you get through it, and you'll get to smoother sailing in originalism land. So if you adopt the middle row position or one like mine, what you end up having to do is you end up, I think, having three different steps. So the first step is the current law, which is this eclecticism. And the second step is where you have a critical mass of originalist judges, and they are drawn by the gravitational pull of originalism to, on a case-by-case and maybe doctrine-by-doctrine basis, start moving the doctrine back to the original meaning. So one way to move it would be to limit the non-originalist precedent. That's actually what I see going on in the Interstate Commerce Clause context. So for those of you who've had the Interstate Commerce Clause, you know that during the New Deal, we got the substantial effects test, and for 50 years, that was just trucking along until Lopez, U.S. versus Lopez in 95. And when you read the Rehnquist opinion, what you see the Supreme Court doing is they're not saying they're overruling the non-originalist precedent, but they're saying thus far and no further. And I take that to be a response to the gravitational pull of the original meaning. And then what happened in NFIB versus Sebelius? They actually added another limit, right? The activity limit, the Congress has to regulate activity limit on the substantial effects test. So that's one response, right? You stop the growth, and maybe that's the right response in that area, because there's so much dependent on the law in that area. But I think Dobbs presents another picture, right? The other picture is you don't overrule the entire body of doctrine, right? Which is what some critics argue the Supreme Court was or is doing. What you do is you overrule precedent. And so in doing that, you move the center of gravity more towards the original meaning. This is still stage number 2. Stage number 3 occurs years later. Maybe you never get there, depending on the factors. But there's a constant tug towards stage 3, and stage 3 is a fully integrated originalist practice where you have a body of doctrine dominated by originalist precedent that are correct articulations and application of the original meaning. And then you are at a kind of a stasis point where the original meaning is a virtuously reinforcing cycle. So going back to Jonathan's question, how would an originalist approach unwind 100 years of precedent? I think the answer from my perspective would be it would depend, and it would be, I think, on a case-by-case or doctrine-by-doctrine basis, move the center of gravity over, and then ultimately the center of gravity flips, and you have an accelerating movement towards an originalist jurisprudence.
Well, one more question from David Wagonmaker. He says, you mentioned earlier that both Hamilton and Brutus assumed a common baseline regarding precedent. Does this suggest that there are pre-constitutional authorities that judges should follow, or that the Constitution might be an equal authority rather than the supreme law?
Yeah, that's a good question. And the way I would answer that is, so within the framework of originalism is the idea about how we understand our Constitution. And originalists point to our Constitution not being the document plus Supreme Court precedent, right? That was a criticism. It is, and it just is, the document in the National Archives. And there are sociological reasons for originalists to adopt that position. It's actually not a part of the theory itself. The theory assumes that the document in the National Archives is the Constitution. So what was I using the reference to Hamilton and to Brutus for? What I was using the reference for was a standard move towards contemporary historical evidence to ascertain what the public meaning of a word or a phrase in the Constitution was. So the phrase I was trying to articulate was the original meaning of the phrase judicial power or judicial power of the United States. And I was looking to, and I just gave an example of just 2 data points. There's a lot more out there of contemporary evidence that would suggest that there was a public meaning and maybe even a legal meaning for the phrase judicial power that included a requirement to follow stare decisis. So I was not suggesting, and I don't think my example suggests that there are these other authorities equal to the Constitution or pre-constitutional. They are just data, they're input into what the public meaning was at the time.
Excellent. Well, it looks like we've come to the end of our questions. Professor Strang, are there any further remarks that you'd like to make in conclusion before we end?
Yeah, I think so. The remark would be, I think this is a really exciting time to be doing original scholarship on stare decisis. As I said, there's kind of a new era that's been reached where for the first few decades, it was a critical stance of Warren and Burger Court jurisprudence. There was this transition period during the Rehnquist Court and much of the Roberts Court. And now I think we're at a point where, with some reliability, although not total consistency, you can have justices who are inclined towards following the original meaning. And so originalism for the first time is kind of burdened with the job of governance. And what it really needs is a theory about how to grapple with the eclectic bodies of law that we're engaged in. And so I think there's opportunities for students and for others to contribute to that conversation. So this is a really hot area, really interesting area.
Absolutely. Well, thank you so much for being with us tonight, Professor Strang, and thank you all who attended tonight. I hope you all found this event as fruitful and interesting as I did. I certainly learned a lot. So please tune in next week for the next in the Challenges to Originalism session. It will be hosted by the Emory University Law School student chapter. And in that session, Professor Strang will respond to the challenge that originalism is a facade made up by conservatives for conservative policy. So thank you again to everyone for attending, and have a good evening.
Thanks, Sarah.
you.